want this mic?
Hello, everyone. So, welcome to Legal Issues. Rick Wood is going to be presenting today. Rick is, you might remember Rick from Mr. and Mrs. PMS, who did the marital session yesterday. But he has expertise in this area as well, besides just being a married man. He's also a practicing attorney in California for 40 plus years. He has a Bachelor of Arts degree from the University of California, Santa Barbara, and a JD from Santa Clara University, and a master's in taxation from Golden Gate University. And his firm's area of practice include estate and tax planning, special needs trusts, guardianships, and conservatorships. So without further ado, I will let Rick go ahead. Thanks, Rick.
All right, thank you. Actually, I'm not going to do this way. We'll do it this way. Forgive me just a second. I've got to get the thing set up so that you guys know that you're in the right session. And that is not it. Oh, here it is. It didn't show up on the bottom. Here we go. Excellent. Thank you. So let me begin with this. If you're anything like me and you sit through the number of hours of genetic stuff, your brain is probably pretty full. And I want to tell you that there's a lot of material to cover. It can be complex. I'm going to try to make it as simple as possible. And I'll tell you, the first piece of advice that I'm going to give everybody that's not yet really up on the screen, at least it's not emphasized, is that in considering the things that we're going to be talking about, it's really important that you seek counsel. And that you don't get just any counsel. You get somebody that has estate planning experience, and importantly, somebody who has drafted a special needs trust before. It'd be helpful if you get a lawyer who's got a special needs child, because then there's personal experience. So I say that because it is really important. The stuff that I'm going to be talking today about is necessarily going to be conceptual, and I hope that you're going to be able to get tidbits of information, specific points that are going to be useful to you. And the reason that I say that is that I've done this in the past, and I've given presentations in other settings as well on the topics, some of which are single topics that we're going to be discussing today. The last time that we did this 2 years ago, they gave me 2 1.5-hour sessions. Today they've given me 1 hour and have told me that they want me to talk about the same things that I've been talking about the last several years. So this is necessarily going to be different. And that might be better for you because the level of detail that I need or that I want to get into is simply not going to be available. The other thing I'll mention is that I'm going to try to put this into 45 minutes so that there will be questions, and the moderator we'll have a microphone or two for those in the audience who have questions. And so unfortunately, I'm going to need to have you, if you can, hold your questions to the end because we've got a number of topics to get through. So here's the overview. What I want to talk about today is what's on this screen. What is estate planning? Well, it's planning for the future of your family. Who needs it? You need it. Your child needs it. You'll see why. When? Now, not later. Say that again. Now, not later. You will see that when I tell you why it is that you need to have a plan in place. Where? You need a local lawyer, special needs estate planning experience. Why? Because this is the child, this is the person that you need to protect above all else and all others. So the how is that we're going to talk about special needs trusts, able accounts, conservatorship. what I call a memorandum or letter of intent. That's a very, very important document. Housing options that are available throughout the country, protection of public benefits, and as everybody, well, if you don't know, I'm going to tell you that there is a wholesale assault on public benefits by those who legislate and make executive decisions in this country. And it is our children who will be impacted, and in fact are being impacted little by little and then state by state. And I don't expect that, at least in the foreseeable future, to change. And therefore, the grabbing onto public benefits while we can is going to be very important. And then lastly, if we can get to a transition to adulthood. So let's start with what everybody wants to talk about and what they think this session is about. So how many people here have a will? How many people here have a trust, a family trust? Okay, here's how I'm going to explain estate planning. If you have any assets in almost any state, in order to avoid probate, you set up a trust. Probate is more expensive than estate planning. Probate is expensive because fees are typically statutorily prescribed, meaning that the legislature says what percentage of the estate the lawyer takes in order to transfer your assets to your heirs, in most instances your children. Probate is public. Probate is lengthy. Probate is a hassle. You set up a trust very simply to avoid probate. We used to say many years ago that you set up a trust in order to reduce or eliminate taxes. But because the tax laws, the estate tax laws, have changed so dramatically over the years, for most of us, unless you're worth as a couple $22 million, we don't have a tax problem. But we still have a probate problem. And so you need to have a plan, and a plan consists as a foundation of a trust. A special needs trust comes in two forms. The purpose is to provide assets during the child's lifetime for his or her use and benefit without disqualifying him or her from receiving public benefits. It's as simple as that. I'm going to show you how it works. There are two types of trusts, first party and third party. We're going to talk about third party first. That goes in your estate plan. So if you have a trust, or if you create one, and you have a child with PMS or any child with any special needs, you're going to have a piece of that trust that says anything that goes to my child actually is going to go into a trust for his or her benefit. Can be used to supplement public benefits. So if your child is receiving public benefits, what's the number one public benefits that children under the age of 18 receive? It's Medicaid and Medi-Cal. When your child ages up to 18, he or she is going to receive SSI, which is supplemental security income. It's kind of similar to Social Security, except you don't pay into it. And those are entitlement programs that you become ineligible for if you own any property in excess of $2,000. So the point is you have to be poor in order to receive public benefits as a child. And so as a practical matter, what do we want to do? Well, we want to make assets available for the child. We know that our child is going to need assets in order to live after we're gone. And so a third-party special needs trust is nothing more than a document that says that the assets go into it for the benefit of the child, because that's the starting point. What's inside of that trust is dependent upon what your needs are. And what I mean by that is that we don't know today what the needs are going to be tomorrow. We also don't know what our estate is going to be. How big is it going to be? Do we have life insurance? Is the life insurance going to be enforced at the time that we pass away? But what we know is that if assets go into the hands of the child, or directly for his benefit, for example, to a conservator, they are going to disqualify him from things that otherwise you're going to be eligible for. So in my practice, special needs trusts 20 years ago were not really common. But they are becoming really common. There are a lot of practitioners now who know how to do them because there's been this explosion in autism diagnoses, and therefore all these little kids 15 or 20 years ago who are 5 years old and were diagnosed as autistic suddenly are 20 years old, they're adults, and their parents are older and so on. And so these things have become a lot more popular. And so the thinking, as you talk to a lawyer about what this is shouldn't be what's the structure of the trust. It should be what should be included in this document in order to take care of my child. So a very typical estate plan for a husband and a wife with, let's say, 3 kids would be husband dies, leaves the estate to wife, wife then dies, leaves the estate to the 3 children equally. If I were to look at 90% of estate plans in this country, that's what I would see. Well, in the case of a special needs trust, if you want to divide your estate, whatever its value, into 3, you would, with that 1/3 piece that goes to your PMS child, you would have that in a special needs trust. It's sort of, so consider it like a sub-trust underneath the overall or the bigger trust. Over the years, my thinking about how you set that up has changed, and the reason is that I know, now that I have an adult child, that the financial requirements are much greater than when that child is living at home. And so one of the thoughts needs to be, well, should we really do a 1/3, 1/3, 1/3 split? Or should we do something different? Should we craft language that requires the successor trustee to do an analysis of what that person's needs are at the time and what they might be into the future to decide how it is that the estate ought to be divided? Should we withhold the 2/3 that would otherwise go to the other kids until the 1/3 that goes to the or whatever's remaining goes to the PMS child to over time to see whether that should or might be exhausted, or maybe there's going to be leftover funds? All of that can be drafted. That's my point. You can say whatever you want to in one of these documents. You just need to think it through, which takes me back to my first point. You need somebody who knows something about this stuff, okay? All right. This is a gigantic topic, and I've just spent 10 minutes telling you about special needs trusts, and it is a complex area. Do not go to LegalZoom and get a special needs trust. If you do, you're probably going to screw it up, or you're going to take it to a lawyer to finish it, and it's probably going to cost you more than than you would otherwise pay. I don't say that because I think that lawyers are the only ones that can do that. I think that there are lots of boilerplate legal stuff out there that can be done without the necessity of a lawyer. This is not one of those. Okay. A first-party special needs trust is one in which it looks just like the third party, except that it's set up today. And it can be, and what goes into it are contributions or assets that might be owned by the child now, or if you've got a family member or a parent who wants to fund something during the child's lifetime to supplement public benefits, it can be funded and those funds can be used. So a first party is nothing more than a trust today into which assets that a child could receive, into which assets would go. And so as a practical matter, most special needs trusts are inside your estate plan, the parent's estate plan. But a first-party special needs trust is a device that is available and useful. If you set one up, it gets its own tax identification number, and to the extent that it earns income, it pays taxes. So it's not something that you just sort of tuck money away like sending money to the Cayman Islands or something. It's a separate entity that is its own taxpayer, all right? Okay, I've got this up here because this is a new thing. And this is an alternative to a special needs trust. We call them ABLE accounts. It was an act that was passed under the Obama administration in 2014, Achieving a Better Life Experience Act. And I want to tell you guys what this is. It's a trust it's an alternative to a trust, and it's an account that looks very much like a 529A educational account, college education fund, where you put money in after tax dollars, and that money grows over time, and the money can be withdrawn to be used for the child for things that relate to disability, including food and housing and medical care, and other things. You can't take the money out and go to Las Vegas and gamble with it, but it is, when it comes out tax-free. And so the growth is tax-free, and the distributions are tax-free. So a lot of questions I get are, well, what if I have a 529A account that's an educational account? Can I transfer those funds into an ABLE account? Well, yes, we can. We couldn't in 2014, but we can now. Second, what if the child has money or assets that should go into that could go into an account? Can that person get a deduction? Well, in California, they passed a law that says, yes, you can deduct from your California state taxes a contribution. Now, that's different from when the act was originally, from the federal act. But the states have implemented it, and in California, and I assume in other states, you can get a tax deduction. The child can get a tax deduction. So if you've got a child that has income, that person can get a tax deduction. That doesn't apply to most of our kids, but it's there nonetheless. So last but not least, well, not really last but not least, two financial pieces. One is the account cannot exceed $102,000. Why? Because if you have more than $2,000, you are not going to be eligible for public benefits. And therefore, you can put up to $102,000 into this and still qualify for public benefits. I think it's a really neat tool because you don't need to go to a lawyer. You go to a broker like Merrill Lynch or Bank of America or Chase, because all these institutions want to begin to take advantage of this. This is not dissimilar from the educational accounts. They took a while when the law was passed years ago on those for them to become popular. Now they are popular because of the growth possibility over time. But it's limited. This is limited to $100,000, 102 actually. And then last but not least, in the event your child dies and there's money left in that account and receives Medi-Cal or Medicaid services, there's a clawback by Medicaid, by the state that administers Medicaid, of whatever has been spent up to whatever's left in the account. And then otherwise, there's a beneficiary of the account, and it's often other children. It could be yourself, and then secondarily your other kids. So it's new, and I expect them to become a lot more popular. All right, so really briefly on conservatorship. I know in a lot of states, conservatorship is called guardianship, and so in states where there is a guardianship for an adult person, the conservatorship rules apply. And by the way, these concepts are the same in every state. There are differences in state by state, but the concepts don't change. So the question becomes, do you need a conservatorship or a guardianship for a child under the age of 18? Not if that child has a competent parent. You don't. You make decisions for your child now. You don't need to have one. The question is, well, what happens at the age of 18? You're making decisions for your child. He or she is not making any decisions at all and can't. And do you need to have something in place that will allow others will give you the authority to make decisions on behalf of your child? And many people say, well, I don't know what that might be. Well, there are many instances in which it might be, and I'll tell you that you divide a conservatorship into two different parts: the conservatorship of the person and conservatorship of the estate. So the conservatorship of the person is one in which you are making non-financial decisions about your child. Things that affect, for example, medical decisions. So if you go into a hospital and the hospital says, who's got authority for us to treat him? Well, gee, I guess I do. Well, no, this child is 21 years old. It's he who has the authority. Well, no, I've got the authority because I'm his parent. Well, you don't have the legal authority. You technically do not have the legal authority to make a decision about whether your child, for example, should be treated in the event that that child is over the age of 21, even though he doesn't have capacity to make a decision himself. And I'm thinking, for example, of a number of the trials that are going on now, in particular the drug trial for seizures that's being conducted by the Seaver Autism Center. Fact is that somebody has to sign for that person's participation in a drug trial, and that person can't because he or she does not have capacity. So that doesn't relate to money. It relates to the person. You make decisions about where that person's going to live. Who would sign a rental agreement? Well, the person can't. Who would sign, if you want to open a bank account and have $1,000 in it, who would sign for that? Well, that person can't. So in my mind, that's something, and I realize you don't have to worry about it until about 17 and a half. But 17 and a half comes sooner than later for those of you who have children under the age of 18. Second one, of course, is the conservatorship of the person, of the estate. This is an instance in which if the child has any financial transaction of any kind, needs to sign a contract for some reason other than something that relates, for example, to medical, somebody has to sign for him. There are a lot of folks out there who do not have conservatorships, and somehow they get away with it. And so you might be in a position where you don't actually want to think about it until you have to. Frankly, that may be okay as well, except that to get a conservatorship, you just don't go down the street or you don't just knock on the courthouse door and say, hey, I want one of these, can you grant it? The court has supervision over you, which means you have to file a petition for conservatorship. And there has to be an assessment. Somebody comes out to your home and assesses whether whether your child lacks capacity. And then a report is done, and then that report gets submitted, and the judge then appoints you as the temporary conservator, and then it becomes final. I've just described a process that, at least in California, takes at least 3 months. And so if there's something that's time sensitive, that could very well be a problem. So what do you do if you need one? You got to go see a lawyer who does conservatorships. Don't see a lawyer who doesn't. They're typically very tedious. They're very form-based in most states, certainly in California, and they're not cheap to do. My estimate, typically in my firm, to do a conservatorship is $2,500 to $3,500. And then you have the privilege of having to go back to court every 2 years and give the court an accounting of whatever monies it is or assets that you are managing, and ask the court to approve your report, and then you go back and you do that every 2 years thereafter. But, here we are. We don't have an alternative. Okay, I want to spend about 5 minutes on this. I want you guys to look at this stuff. I have developed what I call a memorandum or letter of intent, and I don't know that I invented this, but I've sort of taken it, at least in my own practice, to sort of a new level, and that is, I believe that a memorandum of intent is the single most important document that you can do outside of establishing and funding a trust. And the reason for that is we have the knowledge. We know our children. We know strengths, weaknesses. We know the foibles. We know the medications. We know it all. And nobody knows it other than us. And most of us don't really write all of it down. And a memorandum of intent, I developed one many years ago because I thought, well, God, what happens if we go down in an airplane? Who is going to know what to do? And on one hand, you say, well, we've got other children, and we've got caregivers, and we've got people in the community, and we've got physicians, and we've got all these people. But nobody really knows what to do, and you guys know what I mean. And so what I did is I developed this document. And the great thing about the document is that you develop it in real time, and you date it, and you sign it. And if next week you want to add something to it, or you want to change it, or you've just got some thoughts about something that you didn't have based upon the passage of time and your experience, you either tear it up or you add to it and you date it and you sign it again. And that's the document that sits on top of your estate plan in the estate plan notebook. So what I've done in my own practice is I've actually advised all clients who come into my office to do one. Because people say, well, I really want my daughter to have the china that I inherited from my grandmother, and I want to make sure that it's passed along to her. And the husband says, and I want my son to have my guns. And instead of putting all that stuff about stuff, in particular personal property, into a trust, which if it changes, because either your idea changes or maybe you sell the guns or the china or for whatever reason, you don't have to go back to see a lawyer to amend your trust in order to change the plan of distribution. And the way it's always been is that you go back to the lawyer to change your trust. Well, you don't want to do that. It's expensive to go back to the lawyer and change your trust. What you really want to do is have this living document. And so it is not ignored. If that document is with the plan, it sets forth your intent. You can say things like what you want specifically for memorial services, whether you want to be cremated, whether you want your house to not be sold until the happening of an event. You can say whatever you want. There are no rules and there are no limits to what you might want to do. But the reason that I put this up here and the reason I feel so strongly about this is that it's this really easy, informal way for you to tell whoever you're going to leave behind what you expect for the future of your PMS child. And I can't say it any more simply than that. And it's not a document that needs to be notarized. It's easy to do. It's easy to change. Doesn't cost any money. And maybe it turns into a chronicling of your child's life. Maybe it substitutes for a journal. It can be a page. It can be a book. Shouldn't be a book, but it could be. All right. I want to go into housing. So. I don't have to tell anybody in this room that we have a nationwide housing crisis. If you live in an urban area, it's a super crisis. If you live in certain areas, it is astonishing. But it is particularly tough for us because in the end, we've got to find a place for housing for our children, and so the conventional. I don't mean traditional, but the conventional housing for adults with disabilities is currently group homes throughout the country. That is sort of in contrast with or affected by the current thinking about where those with disabilities should sort of fit in the world. And what I mean by that is that what happens is that often adults with disabilities are isolated and they're excluded. And the current nationwide philosophy is that we want inclusion. And what inclusion means is having that person participate in the community. And so group homes are fine. Typically they're 2 to 6 people, and some states have rules, such as California, which will prohibit large group homes. Group homes have replaced the institutions. We don't have those anymore. There are some left, but hardly any, and they're closing down. I think California has one institutional facility left. They began dismantling them during the Reagan years, which was before he became the president. He was the governor of California. And so we don't have these large institutions any longer. And so the institutions are now the homes. And the homes are either the homes of parents or the homes of others where they take in and are paid to take care of those with disabilities. And so that is a form of what I call independent living, or I think what the experts call independent living. Of course, it's not independent. Our children are never going to be independent for the most part, if not entirely. But small settings are going to be the norm. Do you need to start thinking about that now? You just need to start thinking about it, but there's nothing unless you are approaching a time when you no longer want to have your child live with you. That's going to be an option. The second option is what we call Section 8 housing. It's basically subsidized by federal funds. I can tell you if you went to your local housing office, and that would be an arm of either the county or the city in which you live, and ask them about Section 8 housing, they would sort of laugh at you because in many instances there isn't any, and in some instances the wait list, in fact in all other instances, the wait list is typically very, very long, but it provides opportunities for housing that might otherwise, which is less expensive and which might not otherwise be financially feasible for you to get into. So, so when do you do that? Well, you do that before the child leaves. But what I would do, because let's face it, information is, and knowledge is power, as they say, and information gives you the knowledge. I would go find out what's going on in your community if that's where you think your child is going to live, or the community where you think he or she is ultimately going to end up in. Get some information about eligibility for Section 8 housing, because clearly they're going to qualify for Section 8 housing based upon income. It's low-income housing is what it is. I spoke about the group settings earlier, and then, of course, last but not least is the default, which is living with parents, siblings, and caregivers. I think I said in another session that as my child, who's 23 next month, aged up, or was almost aged up. He was just before 18, and we had a discussion with the local people that were that had cared for him medically for all of those years about what we were going to do, and I could not wrap my head around the fact that my child would be leaving my home. I couldn't do it. And I could wrap my head around a conservatorship. We had a special needs trust. All that was easy. But when the question was asked of me, well, what are you going to do? Have you thought about the future? I could only answer it in legal terms. Well, yeah, of course. I'm a lawyer. I'm going to do a conservatorship. And that wasn't the question. The question was, where's he going to live, and who's going to take care of him? And of course, this person was quite blunt and asked me that. And I said, well, he's going to live with us forever. And so she looked at me and she realized, well, he's not ready. So it took 5 years. It took 5 years, and we finally made the decision to acquire housing for him in our community, which is a ski resort, and housing is very expensive, and it gets more expensive every year, and it's just sort of an impossible situation because in my instance, I didn't want his siblings to have to be responsible for him for the rest of his life. And so that is an individual decision as to what you're going to do about the living circumstances. I don't think you have to lay awake at night worrying about it. I think you need to educate yourself as to what the options are and then get your head ready for whatever it is that you choose. In our case, it took 5 years. I think it would only have taken me a couple, but it took my wife another 3 because she wasn't going to let him go. What ultimately turned the corner for us was something that was very pragmatic, and that is because we live in snow country, the houses start on the second level. I mean, we have a 3-story house, but the first level is just how you get in. It's the garage and laundry room and all that sort of stuff because the snow levels are so high that the housing is starts on the second level. And so because he has seizures, we have instances, one, in which we're just scared to death that he's going to fall down the stairs and take the caregiver with him when he's having a seizure, and that's real. And the second is, in some instances, when he has a series of seizures and literally loses the ability to walk or to even stand up, that he needs to be carried down. And we thought, we can't live this way. He can't live this way any longer. It's too dangerous. We need to have a place that is one story. We've got to find that. And as limited as it is in my community, there are a number of condominiums that are available where there is a ground floor unit, and that's what we did. So that's how we solved our problem. That problem is not going to be solved in that way by you guys. There's rental stock available. There's property that you can purchase if you can afford it. But at a point in time, you got to think about housing. And that's the only thing that I'm going to tell you without telling you have to go out and get a place for your child, because I think that your individual circumstances are going to tell you what to do and when to do that or not. Okay. All right. Transition planning. This didn't used to be in my presentations years ago, but now that I've been through it, it is. And I want to talk to you specifically about what happens when your child ages up to 18. Somebody came up to me, by the way, yesterday and said, I'm not going to name the state. I'm from a state in which I have applied for Medicaid and they have denied it. Is that possible? I thought Medicaid was federal. And the fact is that states administer Medicaid dollars. They are subject to rules that the feds will promulgate and the states have to comply with. It is hard for me to imagine that any state would deny Medicaid to a person who otherwise would qualify and who's under the age of 18. And by the way, the qualification is our syndrome. The qualification is the disability that we have very specifically. And I got to tell you, 20 years ago, I didn't know this. And 20 years ago, with all the medical issues, we had insurance. I had basically another mortgage payment every year for 3 years. I was just paying the copays and paying the deductibles. I had no idea. And one would argue, well, how could you not have an idea? Well, I didn't have any idea. I didn't have any experience in it. It never even occurred to me. And somebody said, well, why don't you apply for Medi-Cal, which is what Medicaid is in California? I said, well, I don't know. I thought Medi-Cal was based upon the parent's income, and we wouldn't qualify. Well, that's true unless there's an exception to the general rule, and that is if you have a qualifying disability, you do qualify. So, for those of you who have insurance, go get Medicaid, because if you have Medicaid and insurance, we haven't had a medical bill in 20 years, not $1 of a medical bill, because we have 2 insurance policies. So so I encourage you guys to if you don't receive Medicaid, or if your child doesn't, don't just assume that because you won't qualify on an income-based basis that that he or she is not going to be available. Then, when they age up to 18, they become eligible for SSI. That's not Social Security income. It's supplemental security income for those who qualify, and you have to have a disability. That's not Social Security disability income. That's different. Disability income under Social Security is income that you receive if you become disabled as an adult and you have the requisite number of quarters in to qualify. In other words, you've worked. So this doesn't have anything to do with working, and it's an entitlement. It's automatic. So unless the government takes it away, it's automatic. So what's the current amount of money that those who are receiving SSI receive? It's between $600 and $700 a month. That's it. That's why people with disabilities are poor. That's why they die poor. That's why they need additional assets. That's why you set up a special needs trust. That's why you put money away into an ABLE account, so that you can supplement this $650 that he or she is going to receive with a cost of living adjustment. Ours was $646 at 18. 5 years later, it's now $664. So we've gone up about $19 in 5 years. And so, as you know, that is not going to go very far in today's world. So the alternative, or if there's going to be a supplement, it's going to come either from the family or it's going to come from the government. And so most people that I see in the disabled community, and I'll indicate that, I guess passion finds you. I don't know if you find passion. I think things that you might want to do find you. And what has found me is self-determination in California, and I've been very actively involved and a participant in legislation that has finally brought self-determination to California, and I'm going to be talking about that in a second. But in the course of all of that, and in the work that I do in connection with advocacy for those with disabilities, not just PMS, but in the larger community, and there's 330,000 of them in California, is that I find that people have the same issues that we have. Housing issues, transition issues, adulthood issues, anxiety about what's going to happen after after parents and family are no longer around. And so I will tell you that what we find mostly is that families find themselves in a position where they are taking care of children well into adulthood, but until they can't anymore. Because what we didn't know when we were diagnosed, and we were the 34th, and there were no kids over the age of 5 is that we've got lots of adult children now, and that these kids are actually going to live a long life. And so we have to plan on that. And the best advice that I can give is not lawyer advice. It's just practical advice, and that is start to think about the things that you really don't want to think about, and to start to address things that you normally would otherwise procrastinate on. Seems like I've missed a slide. I don't know whether I have or not, but I'm going to look. Because I want to talk about something that is near and dear to me. Anybody heard of self-determination? All right, they call it self-directed services in some states. I want you guys to know it's the future. It's the future not because California has finally gotten on board, but because California is the most populous state, and we have 330,000 people who currently receive services and supports that are funded by the government. So I'm going to tell you that in California we have something called the Lanterman Act that was passed 40 years ago. And it's a very important act in California because it has decreed or declared that services and supports that are, if you qualify as a person with a developmental disability, are an entitlement. We're entitled to them. That is not true, to my knowledge, in any other state. Now, there are modifications of that in which states have stepped up. Some wealthier states in particular have. There are states that are more progressive than others. Florida is, Massachusetts is, Michigan is. But what has honestly kept us going is the fact that California has an entitlement program. Now, you have to fight like you have to fight everything else on behalf of your child. But there's a new concept, because under the old way, and the way that you guys I know are receiving supports and services, is that you walk into an office and you tell them what the disability is, and you just describe the deficits and the characteristics and all of that, and they tell you what it is you're going to be receiving or what you are eligible to receive. Now, a lot of people say, well, you know, I feel bad that I have to get something from the government. Nonsense. There's lots and lots of people that get stuff from the government, from all sorts of places from the government. Your obligation is to get as much as you can for your child, and that will impact the quality of your life and the quality of the child's life. So this concept called self-determination says, look, we're going to take a look at what the need is, and the need may not be based on, gee, my child needs orthotics, or my child needs diapers, or my child needs a stroller or a wheelchair. It's not that. It's what is going to make the quality of his or her life better. How is he or she going to be happier with his or her life? Now think about that. It has nothing to do with need. It has everything to do with something much larger, which is happiness, which is all we really want for ourselves, and we go about getting that or finding that in ways that don't require necessarily money from the government, but that's what our children are deserving of. So self-determination says, instead of the government telling you what you can get based upon their assessment of your need based upon your disability, you go in and you say, I want this to make my life better. And this may be the same thing that they're offering. But the principles of self-determination include the freedom to choose services and supports, the control over your life, balanced against the accountability for what you receive. So what we've been in a pilot program, just coincidentally, for 20 years, 19. 150 people in the state of California. That program is going live on October 1st of this year after some legislation that we put together to finally extend it and is going to be eligible in 3 years to the entire population. And because California is now on board, I will expect other states to follow. Why? Because the feds are financing it. The federal government is financing it. Takes me back to this assault on Medicaid. We don't know how the assault on Medicaid is going to impact the available dollars, but I can tell you that getting some money is better than getting no money. You guys know what you need. Let me give you just this really simple example. of what of how self-determination has impacted our life. I guarantee you it's impacted us extraordinarily, because self-determination pays for people to care for my child 24/7. Doesn't cost us any money. I'm going to say that again. You take 168 hours a week and put a number of $20 an hour, including the employer's cost, and multiply that by 52, and you get an idea of what money is available for an adult child who actually can live a life of happiness without the necessity of having parents alive, because I know that he's going to outlive me. When we first got into the program, he was 4, almost 4. And one of the things that really bothered me is that we knew that he qualified for diapers. That was just one of the things. He was incontinent. He qualified for diapers. And so we would get these diapers delivered to us that were provided by a vendor through the organization called a regional center that distributes money for the services and supports. And so they would send these diapers, and they would arrive in the mail, and they were just terrible. They didn't work. Even at the age of 3, they didn't work. And so it drove me crazy. I would say, why can't we go down to the store and buy Huggies or Pampers? Because in a competitive economy, you know, at a capitalistic place, they improve their product. And they said, well, you can't do that because these are the vendor's diapers. And that's what you have. We have to go to a vendor. And the vendor is the entity that signs up with the regional center to provide the support or the service. And I just thought that was the dumbest thing I'd ever heard, that they wouldn't basically allow us to do something. So I go down and I said, okay, I'm going to tell you that it's cheaper for me to go buy Huggies, which I did. And they said, well, it doesn't matter. You get what you get. I just thought it made no sense to me at the time. And, of course, his needs increased over time, but it illustrated the obvious. We get into self-determination. The first thing I do is I get rid of the vendor, and I go to Costco, and I start buying Huggies. And now there depends. But the point is that it allowed me the opportunity to make the choice. Now, think about the concept. That's coming to your state. I can guarantee it, because once California is on board, and it is, and we're working very hard to make this work, it will ultimately influence the outcome or influence how services are delivered. And the last thing I'm going to say, I know I'm in trouble, because I know I'm in trouble. The last thing I'm going to say is that what has been demonstrated in this pilot that we've been doing for 19 years is that it is revenue neutral, which means, and we went to the legislature in California and got this law passed to extend it, because they couldn't even imagine that if you gave money to people, public money to people, that they would not steal from you, or that they would not spend it correctly or appropriately. And what we've proven, and what we will continue to demonstrate, and by the way, how it works is, I get a check every month. Now, mine's a little bit different than the way it's going to go, because an accountant has to actually get the check under the new law. I get a check in advance. Think about this, and then I'm going to finish in 10 seconds. 30. Think about this. You hire a babysitter, right, because you want to go out to dinner, and you get that paid for because the state says, we're going to give you respite. You get 6 hours of respite a month, which I think is stupid, and that's not even a term in my plan. You go out to dinner. How is that person paid? You pay the person, right? Because if you relied on the state to pay, you would submit a bill at the end of the month, and then by the end of the following month, you would get the check for the 3 hours that you went out to dinner, which means you can't find a babysitter who is going to wait 60, 45, or 30 days to get paid for the services that were rendered at the time. We experienced that. Fortunately, we were able to pay the babysitter, or we didn't go out. And so, but the point is, that's just another example of where you take control, or have the opportunity to take control of your own financial situation. Ultimately, it's happiness that counts. So remember that term. It's coming. Listen, that's all I have, and I can see that I'm well over my time, or I'm actually approaching the time that I had before questions. And so my understanding is that there is 15 minutes of time, or now 10 minutes of time for questions from the audience. By the way, I just took a 3-hour presentation and compressed it into like 50 minutes. I don't know.
Okay, so if I go to court, get a conservative, I can't say the word, conservatorship or guardianship, I'll say guardianship, for my child, and she's an adult, when something happens to me or my husband who are guardians, does whoever we say in our will is going to be her guardian have to now go get a new conservative?
Great question. So you designate or you nominate by way of suggestion in your plan, in your estate plan, whether it's a will or a trust, who is going to serve as the successor, guardian, or conservator of the person and estate of your child. It's not a guarantee, but if you are expressing a preference, it is likely to be followed.
Okay.
Thanks for that really excellent presentation. I just wanted to say, as a mom of a 31-year-old young woman who's living outside my home for the last 3 years, that another reason to really start thinking about this on the early side is that developmentally, even our kids are sort of behind, but they just follow this kind of same order, I think, and that it's going to be a lot easier on the child to be moving to a different place when they're still in their mid-20s, their early 30s, than to look up at age 50 and have to adapt to a completely different thing. So it's just another reason to think about this.
Okay.
I'm sorry. There you go.
Yes. First, thank you, Rick, for doing this. I always appreciate it. The ABLE account, can you combine that with the third-party special needs trust? We already have a third-party special needs trust, and you can
it's an alternative, but it's a separate, and it doesn't.
It's okay to do it though, right?
It wouldn't go. It wouldn't go through. No, you don't. You wouldn't come. Oh, you mean do both at the same time? Oh yeah.
Yeah. Okay.
Absolutely.
And that's my very brief question. The real question is, if somebody that's well-meaning tries to leave money to our child, how do you reject it? You just legally can set up a process in place where they can take no money?
I never reject money that's offered to me.
No, I mean I'm gone. The parents are gone. Somebody tries to leave money when they're gone.
You should tell your whole family and friends to leave money to their special needs trust.
Yeah, well, we do that.
And if they don't do that, you're going to have to go through.
But there are friends and there are other people we encounter that they say, we want to give a gift later or we want to do 10% of what we're going to leave behind because they like Christopher.
One, if you set up an ABLE account, and you can only put $15,000 a year into it, but just like the 529s, I know that ABLE accounts, once they become popular, are going to change and there are going to be different limits. I don't know that, but I think so. But they can contribute to an ABLE account, or if they want to give something to a child, a first-party special needs trust would then be set up for that child. So it's just like one that would be in your plan, except that the child sets it up with money that he or she has been given. And if you do that in the year in which you receive it, it just goes in. There's no reporting. It's fine. It works. Well, you don't have to take money that's given to you, but you need to protect the money. You need to shield the money from the scrutiny of the federal government in order to continue to receive benefits.
So really a couple comments more than anything else, but as far as the Medicaid, or in your case Medi-Cal, I couldn't possibly agree more. It's been huge for us in the sense that even though I'm well employed and have insurance, we don't pay a dime for anything.
Yeah.
And I don't worry about where do I take her, is it going to be covered? I'm like, her healthcare needs are completely taken care of. The comment I will make on that that's super annoying to me, it is a carve-out clause that they qualify for. Every year is still applying. Every year, show me your W-2, show me your entire assets, show me everything. And I'll submit them, and I'm like, this has absolutely nothing to do with what my daughter's going to qualify on, yet you still want to go through everything you have just to say, yep, she qualifies on an exception. So that part is frustrating, but it is what it is. Okay, so here's the point. It's because the disability qualifies the child for benefits, for Medicaid. Theoretically, other than the child's income, of which there is none typically, you're not going to have to fill out the forms. Every year you have to reapply, right? And you have to, and so this whole section about the family income, or the income of the members of the household and the assets and so on, I just ignore. And of course I'm in a small town and they know my child, and then nobody questions anything and so on. But the point of it is that if somebody tries to tell you it's income based or asset based, that is the qualification, they're wrong. It's not. It's not. At least in Pennsylvania, it's online. You cannot submit your application without actually providing all the documentation. Period. End of story. And that's super frustrating.
Yeah, yeah.
And the other quick question I had is related to the ABLE accounts. I guess I shouldn't really care if I'm gone and my PMS child has passed away, but the clawback's almost guaranteed to be the entire value of the account, I would think, because they're huge consumers of health care and cost.
Yeah. Yeah, that's inevitable. Sorry. I don't know if I actually put that on the screen because I just can't stand putting it out there, but the fact is that it's true. If there's any money left over and the child dies and is receiving Medicaid or in California Medi-Cal, then there's going to be a clawback.
I have the question about the special needs trust. Can you put a physical asset into a trust of property, for example? My child is very soon going to inherit a third of my ex-husband's home.
Yes. Yes, absolutely. It's not limited to financial accounts, not limited to cash. Title to that 1/3 is going to be in the name of the first party special needs trust, if indeed that's the vehicle that is chosen, or if there's is he under the age of 18? Yeah, so it'd be in the name of the special needs trust. Yeah.
Going back to Medicaid, so we always thought we wouldn't qualify, so we never applied. So can you just talk through that a little bit? I don't know if anybody else had the same experience. So what's the process like? Where do we go? And I know it's going to be different for every state, but maybe a blueprint would help so we can figure it out for our state.
So typically it's your local social services entity, and that's often I think in most states run by counties. They administer the federal funds. The truth is they don't administer. There's two layers of administration. The feds send the money to the state then sends the money to the counties, and so the counties are acting on behalf of the state. So what you need to know are the rules of the state, but the county knows that, and what you need to do is just have them get rid of this notion that there is income qualification other than the child's income. And say, no, I understand that there's an exception. I know that because there are people all over the place with this condition, with this syndrome, who do qualify and receive benefits. And it's like everything else. I don't know what the rules are in your state in terms of administering the money, but I would advocate and push until you feel that you've gone as far as you can go. If they continue to say no, it's really the best I can say.
So, I mean, how does that work from, like, when you're saying you're not paying any bills, like, it's like it goes through your insurance and then Medi-Cal covers the rest? Is that?
No, it goes the other way. It goes through, Medi-Cal is the primary, it becomes the primary provider.
Oh, okay.
And then the insurance picks up the rest. It can work the other way if your medical institution, if your hospital or your doctor has your, say, Blue Cross insurance as primary, and then they bill Medi-Cal for whatever is not covered. But here's the reason. You never pay because if you have Medicaid, they can't look to any other source beyond. In other words, if there's a deductible, Medicaid doesn't pay as much as insurance companies pay. And even if there's a copay or a deductible, if Medicaid doesn't pay enough to cover the copay or the deductible, you don't have to pay any more. There's no out-of-pocket cost whatsoever.
Okay.
So does that mean that the provider doesn't necessarily have to accept Medicaid?
That's correct. And just like a provider doesn't have to accept Medicare. See my color of my hair? I'm in that category. But throughout the country, there are areas that this is not true. There are so many people on Medicaid that doctors, in many instances, simply cannot afford not to take Medicaid patients.
I want to speak to the exception to that. Texas, right here where we're sitting, they have waiver programs, but there are waiting lists that are about 16 years. So you may need to be getting on this sooner instead of later. It does depend on the state, and the state of Texas we use our personal insurance first and Medicaid second, and we go to some doctors who do not accept his Medicaid, but we prefer that doctor over the cattle guard approach of the other doctors.
Yeah, so I heard that yesterday. I heard 15-year waiting list. This is simply beyond my imagination.
States have been sued, or there's ongoing suits because of the waiting lists for that. And Michigan was one of the states that was sued over those waiver waiting lists.
I want to say that one thing that could be really useful here is your regional coordinators, because somebody in your region, in your state, has probably succeeded. If you're going to go do it, so for example, like we're in Washington, and Washington opened a new IFS waiver, which is the Medicaid waiver, and we just happened to be in the right place at the right time, and we got in. So coordinating with your regions, like we let everybody else know in Washington, if you want to get in, apply now because they just opened it. So that sort of thing.
Boy, that's a great point, and that is to draw upon the knowledge of those who are in your state, in your region, or in your state in particular. Yeah.
And I had a different question. Since I'm controlling the mic, I'm going to ask it. ABLE accounts, $102,000 max. Is that the max value that the account can ever reach, or is that the max value that you can put into it?
Nope, great question. If you put in 10 and you were early on Apple stock and it went up, the account can be just as big as you want. It disqualifies you from receiving benefits. So in other words, that portion above 102 subjects you to or disqualifies you from receiving Medicaid or SSI.
So it would be really great to leave instructions that whoever owns that account down the road, draw it down to 102. Down, you know.
Yeah, no, that's a good example of something that could go into a memorandum of intent, just as a heads up, because people just don't know this stuff, and nor can you expect them to know all this stuff. And the rules change all the time anyway. But this is going to be an evolving product. It's a product that was created by virtue of this law in 2014. Like a lot of laws, it's taken time to implement. It was up to the legislation calls for the states to put together these programs, just like they did for 529 educational accounts. So, yeah, it will evolve over time. But yeah, anything that is on your mind that you think is important for somebody to know, put it into the memorandum.
Just a thought, another question about the ABLE accounts. I mean, first of all, does it make sense to have people, if you have an ABLE account and a special needs trust, it makes sense to empty the ABLE account first then? And then the second question is, can people add to the ABLE account at any point? In other words, after you're gone, could, you know, a sibling or anyone else?
As long as it's, in answer to your second question, yes, as long as it's open, people can add to it. And yes, it makes sense to draw that down first. Now, there are currently some restrictions or limits on what you can spend ABLE money on, meaning it has to relate to the disability or the basic necessities of life, which would be, you know, housing and clothing and food and so on, and medical stuff. Special needs trust you can spend it to supplement. You can spend it on anything that you want to, and therefore you're not limited. And so, yeah, the correct strategy, if you have both, is to draw against or down the ABLE account first.
All right, we have time for one more question. We're actually past time, but.
I'm going to make it 2 and cheat. They're both about the ABLE account, though. So you can take disbursements from the ABLE account anytime, though. So I could put $15,000 in it now and spend $5,000 of it tomorrow.
Yes.
And then can you roll your ABLE into your special needs trust or money from your ABLE into your special needs trust?
No, I'm not aware that you can. But in terms of drawing it down, you might ask, well, then why do you have if you can draw money out of it, why have an ABLE account? Because the withdrawals are tax-free because it's after-tax dollars that go into the account, but more importantly, the incremental increase, meaning the accumulations, that would be appreciation of assets or interest income or dividend income, once you draw them out, are not subject to taxation, so they avoid taxation.
It's a Roth vehicle, essentially, for your child's needs.
Yeah. If anybody has any question, one last comment. People ask me, will you review my special needs trust because I don't trust my special needs trust attorney? Yes. Oh, look, I didn't put my email. Maybe that was deliberate. I'm happy to look at anybody's trust. There are a lot of experts in the field. I'm just one that's done a lot of these now over the years. Secondly, I'm available for questions throughout the rest of the conference. And then finally, my email is rick@woodlawgroup, rick@woodlawgroup.com. If you want, and I think I'm probably somewhere in the brochure. But so if you want to, people call me or find me or email me regularly after these conferences, and that's not just in the week or two after. I'm not saying I'm the only person that has the knowledge base. I'm not. But if you want somebody else to take a look, or if you got a question, I'm happy to answer it.
Thank you, Rick.